How do we define domestic violence under Maine law? Well, first of all, there are different forms of domestic violence. There's domestic violence assault, there's domestic violence stalking, there's domestic violence terrorizing, there's domestic violence criminal threatening, there's aggravated domestic violence assault. So there's a number of different types of crimes that fall under domestic violence. But the key here is, in order to qualify as domestic violence, you've got to meet the definition of either family or household member or dating partner. Okay, so dating partner, if you're dating someone and there's an assault that occurs, it will be charged as domestic violence. If it's alleged that you get way too physical with your child, you think that this is corporal discipline, it's within the parental realm, but it gets out of hand, you could be charged with domestic violence in that stage of the case. Involves your wife, your ex-wife, former dating partners, former sexual partners. Essentially, if you have a direct line connection when it comes to familial connection, your parents, your child, your wife, your dating partner, your sexual partner, that all falls under domestic violence. And then the type of crime needs to then be determined. Again, was it an assault? Was it terrorizing, criminal threatening, stalking? There's a whole host of crimes that fall under the umbrella of domestic violence. But it all starts with determining, is this a crime of domestic violence based on the relationship with the alleged victim, or is this just a run-of-the-mill assault, stalking, whatnot? Here's a classic example of you can be arrested even though you didn't inflict injury or pain on someone. In a domestic violence situation, these are heightened emotional situations. They involve family members. And when you involve family and law enforcement gets involved, it's highly volatile, and the courts are very aware of it. So domestic violence is a significantly worse charge than just a regular assault. But you can still be charged with domestic violence assault and you didn't hurt your partner. For example, you're arguing with your wife, it's back and forth, and you get tired of hearing whatever she says you haven't done today. You didn't mow the lawn, you didn't paint the house, you're no good, whatever it is. And you're finally like, fuck it. I've had enough of you. And you throw your papers that you had in front of you up in the air, and a couple of them hit her. That could be offensive physical contact. That is literally enough for her to pick up the phone, call 911 and say, I was just assaulted by my husband. You don't have to inflict visible injury. She doesn't have to be in pain. It could be something like that. Also, you don't have to assault someone in order to be charged with domestic violence. You could threaten someone. You could say to your wife, if you tell me that one more fucking time, I'm going to put your head through the fucking wall, lady. That sounds to me like that's going to qualify as domestic violence, criminal threatening, because you're saying if you say one more thing, here's what I'm going to do, and it's imminent. I'm going to assault you. So you haven't touched her, but you threatened to do so, and because she's your wife, that will qualify as criminal threatening. So there's two examples of where you don't actually have to hurt someone in the sense of inflicting physical pain or injury, but it still qualifies as a crime of domestic violence. And one thing to be clear, a female can be charged as readily as a male. Also, same-sex couples either one can be charged. So this is not a crime that's strictly related to males. We represent females, we represent males in same-sex marriages, females in same-sex marriages, same-sex relationships. So I want to be really clear, this is not just applying to men. It can apply to women as well. The first question people want to know is, can I go home? You were just charged with domestic violence. The answer, sadly, is in 99.9% of the cases, right out of the gate, you cannot go home. Courts take these charges really seriously. Why? Because in too many cases historically, even in the recent past, where there's been an explosive episode of domestic violence, when oftentimes or sometimes when that person goes home, this ends up later resulting in a murder. The number one reason for most murders involving two people who know each other in Maine is probably domestic violence related, which is very sad. And because of that, courts are afraid to let people just go back home. So there's always going to be a bail condition that says you may not return to the residence. You may not have contact with the alleged victim, who might be your wife, could be your child. And if you are allowed to return home, it's one time with a sheriff's deputy to grab your clothing and essentials, and that's it. You don't get to go carry out half the household, and take half a day. And this has real life impact. You're the sole support of the family. Now what do? I've got to split my income between paying and making sure my family's still taken care of, getting an attorney involved, and I got to find a place to live because I can't go home. I literally had a client tell me that they lived under a bridge in their car for 3 days before they were able to find suitable housing because of that bail condition. So what can be done? At some point, we need to modify the bail and try and get some level of normalcy reestablished between you and the alleged victim. And when I say the alleged victim, these are the labels the court places upon you and everyone else. You are the defendant. Your wife or your significant other, he or she is the victim. That's how the court treats this. So when I say terms like defendant and victim, I'm using the court terminology. This isn't just terminology I'm just coming up in my own mind and assigning to you. But we have to get your bail modified to try and get you back home. In some cases, we can do that all at once, get you back home. But more likely, we're going to take it in stages. Some type of contact, electronic, so you can have text, phone contact, email contact, maybe in-person public contact. Maybe that's the first stage, and then later we can get you back home. But we have to be conservative about how we approach this because we don't want to make a motion to amend bail and have it completely, flatly denied, and then you're really out in the cold. So this is why it's important to be able to have these discussions with your attorney, find out what your objectives are, learn what is likely and realistic, and then come up with a plan for your particular case. In domestic violence cases, bail is imposed. And as I've said before, 99.9% of the cases where bail is imposed, it also has a condition that says you may not return to the home, you may not have any contact, direct or indirect, with the victim named in the case. And then there's a little bit of a wrinkle here. So you've got these bail protections in place that ensure that you're not going to commit a new crime and also gives the alleged victim some protection. But what we see very commonly in domestic violence cases is someone, i.e. your spouse, might be your soon-to-be ex-spouse, files a protective order, protection from abuse. We usually see that being filed within a few days of the initial arrest, especially if there are children involved. And that's usually a signal that here's what to expect. You're probably going to get divorced now. So be ready for a fight. I consider a protection from abuse case to be the greatest gift you could give me as a defense attorney. Why would I say that? You've been charged with domestic violence assault. Now your wife files a PFA, or protection from abuse case. That's civil. Your worst case scenario is it gets granted against you. Yeah, we want to win. We want to go to court and win, but what do we really want to do? We want a free shot at the alleged victim to testify, get her or his testimony on the record, cross-examine him or her, and then use that in your defense on the criminal case. Because you're not going to jail because a PFA was put on you. You're going to jail if you're convicted of domestic violence. And that's the difference. So when somebody files a PFA against you, I consider that a gift. It's an opportunity for us to really dig into this case, dig into the facts, and maybe blow up the criminal case before it can really gain steam and get started. If you have questions about domestic violence, I'm attorney William Bly. Give the Maine Criminal Defense Group a call. You've got a team of experienced trial attorneys ready to discuss your case and move forward with the defense. We look forward to hearing from you.